I open this hearing of the Finance and Public Admin Committee into the 22-23 budget estimates. I begin, importantly, by acknowledging the traditional custodians of the land on which we meet today and pay my respects to elders, past and present. I extend that respect to Aboriginal and Torres Strait Islander peoples here today. The committee is due to report to the Senate on or before 22nd of December and has fixed Monday the 16th of January as the date for the return of answers to questions taken on notice. Today we continue our examination of the budget estimates for 22-23 with the cross-portfolio hearing on Indigenous matters as listed on today's program. Understanding Order 26, we will take all evidence in public session, including answers to questions on notice. I remind witnesses that in giving evidence to the committee, you're protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence. We have endorsed as the Senate the following test of relevance of questions at estimates hearings. Any questions going to the operations of financial positions of departments and agencies which are seeking funds for the purposes of estimates hearings. I remind officers that the Senate's resolved there are no areas in connection with the expenditure of public funds where any person has a discretion to withhold details or explanations from the Parliament unless or its committees unless the Parliament has expressly provided otherwise. The Senate has resolved that an officer of a department of the Commonwealth shall not be asked to give opinions on matters of public policy, and shall be given a reasonable opportunity to refer questions asked of the officer to a superior officer or minister. This does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. Witnesses are reminded that the Senate order specifying the process of public immunity, interest immunity should be raised. And witnesses are specifically reminded that a statement that information or a document is confidential or consists of advice to government is not a statement that meets the requirements of the 2009 order. Instead, witnesses are required to provide some specific indication of the harm to the public interest that could result from disclosure of the information or the document. An officer answering a question for the first time should state their full name and capacity in which they appear. I remind committee members and witnesses who are appearing via video conference who are not speaking to mute their microphones. Okay, with that done, I'd now like to welcome the Honourable Melandiri McCarthy, Assistant Minister for Indigenous Australians and Assistant Minister for Indigenous Health, Ms Penny Talbot, Executive Director of Township Leasing, and other officers, as well as all senators here today. Ms Talbot, would you like to make an opening statement this morning? I should just say, because we're online, we've got Senator Colbeck, Senator Jana Stewart, Senator Jacinta Nampijinpa Price, Senator Kerry-Ann Little, and myself, Senator Louise Pratt, as chair. Have I missed anyone? I can now. Senator McGrath, you're online as well. I just couldn't see your name listed. But I'm pleased to welcome you also. Ms Penny Talbot, would you like to make an opening statement?
Yes, Chair, if time permits.
If time does permit, of just a couple of minutes. Thank you.
No worries, thank you. Good morning, Senators. Penny Talbot, Executive Director of Township Leasing. First, I would like to acknowledge the Ngunnawal and Ngambri traditional owners. I pay my respects to your families and elders, and I thank you for allowing me to gather on your country with my colleagues, Ms Annette Murtagh and Ms Penny Brown. I would also like to pay my respects to all other traditional owners who have walked this land before us, and all of us that are now responsible for our ancestral lands, stories and families across this nation. Furthermore, I acknowledge and pay my respects to my sisters and brothers and colleagues in the room today. My name is Penny Talbot, and I thank you for the opportunity to discuss the township lease model and work undertaken by my office, the Office of Township Leasing. It is a privilege to be in a position of true partnership with traditional owners, and one that I hold in the highest regard. And I acknowledge the lasting influence of the late Mantiupi leader, Mr. Walter Karanoa, the grandfather of township leasing. It is Mr. Karanoa's vision that inspired the township leasing model. His words, I quote, "I want to empower my people by providing choices that we in the bush have never had before." We're instrumental in establishing the model and embedding a true and lasting partnership between the Executive Director and traditional owners. A leader before his time, his vision continues to have an intergenerational impact on his family and community. Importantly, it is this vision that underpins and influences a strong foundation of the township lease model, providing a platform to enable and drive choice for other Aboriginal traditional owners, families and communities. I would like to take a moment to thank the Karanoa and Mantiupi families for leading the way and allowing us to continue to integrate Mr. Karanoa's vision. The model is embedded in the Aboriginal Land Rights Act, Northern Territory, 1976, the strongest form of land rights and beneficial legislation across the nation. I acknowledge our elders, past leaders and the land councils for fighting for this right. The primary objective behind the Section 19A amendment strengthens this right and is to enable Aboriginal people to have the same opportunities as other Australians living in towns. By providing this mechanism to establish secure, tradable land tenure for townships established on Aboriginal land, whilst maintaining the underlying Aboriginal land title and ongoing cultural responsibilities. Building on culturally legitimate decision-making structures and ensuring space and time for traditional owners to make free, prior and informed decisions is fundamental to the ongoing success of the model, whether it be through the governing arrangement of a community entity or the partnership approach of the consultative forum with the Executive Director. In this partnered decision-making environment, traditional owners are central to all decisions made in relation to land and economic development under their township lease. This has led to social and economic development based on cultural and environmental knowledge, established joint venture opportunities, and embedded development based on planning principles. First and foremost, the governing environment supports choice, providing a trusted space to enable a robust discussion and informed decisions upheld by the office. Whether proposals are supported or not supported, I see my role to support and enable decisions, not be the decision maker. I am aware that the model...
in a position...
Sorry.
Thank you. I just wanted to check in and see how much longer your opening statement
I might jump for you, Chair, if that's okay. I did prepare a shorter one.
Yeah.
I understand it's been
Great.
tabled.
Terrific.
So, sorry. We're about to...
No, that's terrific if you understand it's been tabled.
To achieve this, the office has developed...
If I can draw you to your conclusion.
Yeah. I see my role
Thank
to support and enable decisions, building on culturally legitimate decision-making structures, ensuring space and time for traditional owners to make free and prior decisions. To achieve this, the office has developed a draft township leasing framework. The framework will ensure that traditional owners are at the centre when implementing the model, from the initial engagement through to agreement making. The delivery of land administration arrangements and realisation of economic development opportunities, traditional owners are empowered to make informed decisions through all stages of their township leasing journey. As the model has established itself and more traditional owners express an interest in the model, it is imperative that the office, alongside the land councils, continues to share this information and knowledge. In developing the framework and authorising environment, the traditional owners will be supported to make a free, prior and informed decision if the objective of township leasing model is something they desire. If traditional owners choose to partner with the Executive Director, building strong and sustainable foundations to empower traditional owners to govern and administer their traditional lands, if and when they are ready to transition, should be a central and positive obligation for the Executive Director. The framework supports choice. Choice drives agency and self-determination and creates partnerships based on collaboration and trust. Each traditional owner group and township is different. However, through the model, all traditional owner groups have been empowered by choice. Choice is fundamentally a human right. Mr. Karanoa has established the foundations. The Andiliaqua, Gumatj, Mira and Anagu and Tiwi families have continued this legacy and lead the way. I encourage all stakeholders to follow and continue the partnership to realise an alternative future for our remote townships and Aboriginal people in the Northern Territory. I thank my colleagues in the office and for their ongoing commitment, and I look forward to continuing to work closely with key stakeholders, including traditional owners, the National Indigenous Australians Agency, land councils to empower traditional owners to advance economic and social opportunities through the implementation of a robust township lease model. Thank you, Chair.
Thank you. Thank you very much, Ms Talbot. We'll now go to questions and I give the call to Senator Naparjita Price.
Thank you, Chair, and thank you, Penny, and for your staff who are in attendance today also. I just have a few questions to go through. Can you please outline to me how the Office of Township Leasing determines who a traditional owner is for the purposes of negotiating leases and economic development opportunities?
Thank you, Senator. My legislative function doesn't extend to determining who are Aboriginal or traditional owners. That legislative function resides with the Aboriginal Land Councils of the Northern Territory. So that's something that I would have to probably not advise you on.
Okay, so that's a function of the Northern Land Council, and you take advice from that entity with regard to who they are.
Yeah, so Senator, that's also the Tiwi Land Council, the Andiliaqua and Central Land Councils in the regions that we operate with them.
Okay, thank you. So if the land councils have a meeting that has reviewed a proposal for an economic activity to take place, and all traditional owners and the executive of a land council have supported the proposal in principle, does the Office of Township Leasing then consult with traditional owners, or that's already established and determined? And how can you, I guess, I'm aware of the possibility of disputes in that area, so how can you be sure that you're dealing with the appropriate traditional owners, I guess, is what I'm seeking to understand.
So, sorry, Senator, is that at the negotiation or post the township lease being signed with the Executive Director? So the initial process undertaken by the land councils through the township lease advises that they will nominate traditional owners. However, what I can advise the committee is, so an example being when the Tiwi the Mantiupui family group signed their lease in 2007, there were approximately 5 traditional owners members who were at the table with the Executive Director. At the recent consultative forum held earlier this year, there were 105 members in attendance. So there's the ability post-signing to allow traditional owners to reflect the decision-making environments of their cultural, decision-making processes. So all our consultative forums are very, very unique in their own rights. So I can advise you in Mutijulu, there's a mixture of both traditional owners and community representatives who attend the consultative forum, so that it allows for open and transparent communication to take place, and then the decision-making structures as appropriate kick into that space. So each consultative forum organically reflects, and I'm guided by traditional owners and community when we go into those township leases.
Can you describe to me what, I guess, culturally legitimate decision-making is, what that process looks like?
I suppose when the office pivots to each cultural traditional owner group. So how I apply the consultative forum mechanism in Tiwi to Groote Eylandt and into Mutijulu all look vastly different, and is based on the cultural sort of constructs of each community. And Senator, I suppose I'm not in a position to determine what the cultural constructs are. I'm very much guided by each group. And I think what establishes the primary thing is it's a traditional owner-led process, and they are able to then guide me in that partnership to say this is what we think it should look like. And I think by building that trusted environment, what you start to see is there's no I'm a traditional owner and I should be at the table, and I'm not a traditional owner and I shouldn't be. There's this trust that starts to establish itself through the work of the office and traditional owner groups. So when I say culturally legitimately, I'm like I said, I'm adapting and pivoting to each traditional owner group. So I don't apply a structured, it doesn't come from our office. We provide sort of, a systematic sort of approach to say this is what the information that will go before traditional owners, but then, like I said, we pivot and adapt to each area.
Do you maintain then paperwork for the purpose of OTL to have these processes on record?
So all our consultative forum meetings, the members receive a members pack. They are minuted, and the members are fully informed in each process, and they have all the documentation. So we structure it as like a meeting. We're guided by if we need an interpreter at the table or not, depending on sort of the group and the language barriers that may exist.
And do the traditional owner groups at all change over time, as in from one group it transitions into another for a particular area at all?
The footprint of the township lease normally, it's quite a micro sort of environment. So again, I'll probably refer to one of the Tiwi groups. So in Manti-Upwi's area, they have 5 family groups that are represented, and there was a decision taken early on in the piece that all 5 families are represented at the table, even though that the footprint of the township only may include a couple of those family groups. So again, you're guided by that, and that's so. I would say traditional owners don't change through the process of engaging through the township lease model.
Okay. Given Office of Township Leasing is mandated by legislation to consult and bring parties together to negotiate leases for the express purpose of economic prosperity of remote territory Aboriginal people, can you please outline how many inquiries and complaints you have received for not consulting with traditional owners, and how this has been managed?
So, Senator, I can advise you we haven't received any formal complaints to date.
Thank you. How important is Aboriginal governance and autonomy to the Commonwealth Parliament? I guess it's it appears as though it's possibly a loose sort of structure, and you're relying on I guess individuals, certainly traditional owners, but a system that I guess you're not particularly. There's no real structure around the system of determination of traditional owners, and you're relying on the honesty of those representing, I guess.
So, sorry, Senator, you're probably, I am relying on the legislative functions of the land councils to guide me to the initial stages of signing the township lease. And then traditional owners very much, they are at the centre of that discussion. I recently observed in one of the meetings, like I said, it was one of the quite larger ones, where members did ask the person in the room that you're in attendance today and you're not from this family group. There was no, it was just a question that was posed. They thought that they could attend from an organisational perspective, and they were just politely asked to exit the room because the decision-making environment is reflective of their traditional structures. So I suppose it's not for me to question traditional ownership. I think if we were to have a question posed for us that traditional ownership was in question, then we would certainly work with the land councils and their statutory function to inform that process.
Do you keep record, or can you outline to me what percentage of traditional owner women you consult with and what men you consult with?
So, Senator, I can probably give you, and take that on notice, but I could probably give you a reflection of probably the last calendar year of the consultative forums held, the percentage of women to men. I am actually really pleased to say into the committee today that is actually a really strong representation of women in each of the consultative forums and the engagement of youth into those consultative forums. So, like I said, that's created a trusted environment so that women are at the table, and they are, they are making decisions alongside of our men as well.
Okay, is it possible to get an idea, perhaps take on notice the percentage of women representing?
Yes, Senator, I can take that on notice and get that back to the committee.
Thank you. In reports to Parliament in the past, the Office of Township Leasing has admitted that they lack the expertise and skills to negotiate leases and that they have no skilled assets in Darwin. Can the Minister describe the corporate capacity or competence of the OTL to manage commercial subleases in non-English speaking remote Aboriginal communities?
Sorry, is that question directed at me or the Minister?
If it's been directed at the Minister, but if you have the opportunity to be able to answer that question.
So, Senator, can I just ask, so I can answer correctly, when you talk about commercial subleases, can I understand the context of that? Because I think there's two parts to the question. One is the negotiation to lead into a commercial sublease, not the township lease. Is that correct?
Yeah, that's correct.
Okay. Minister, are you okay if I answer that question? And I can
Yes, go ahead, Michelle.
So one thing that, so there's a variety of different sublease arrangements or underlease arrangements in the case of Mutijulu, because I hold a sublease from the Director of National Parks. And we have a standard procedural environment that applies a methodology to assess the relevant applications that are received by the office. If there are more complicated commercial development type subleases that we receive as applications, we will look to buy in industry expertise to assist us with that preliminary assessment piece so that we're going to the table with traditional owners with an informed technical sort of aspect to that proposal. So we understand where our capacity sits, and like I said, if it's a very specific requirement to a specific development, then certainly that we rely on industry experts to bring that knowledge to the table for traditional owners to discuss and consider the proposal. Does that answer your question, Senator?
Yes, thank you. And who then holds whose name is the other leases held in? Are they in the traditional owners?
Sorry, Senator, so are you talking about the township leases now rather than the subleases?
Yes.
Okay, so what I can advise is that I currently hold a number of township leases. So three leases cover 4 communities in the Tiwi Islands of Waramianga, Milikapiti, Ranku and Palangapi. I also hold a lease in partnership with the Mutijulu, over the Mutijulu township. I recently transferred the one lease that covered the 3 communities in the Groote Island archipelago, which covers Anuragu, Umbakamba and the Miliakburra townships. That has been transferred to a community entity which is now governed directly by traditional owners. And then there are 2 other community entity leases held by traditional owner groups, and they are in Gunyangara, in Ski Beach in East Arnhem, and by the Mirror in Jabiru Township.
So that's under, sorry, when you say you, is that Office of Township Lease or is that you personally?
No, so I hold the, in partnership with traditional owners over the Tiwis and Mutijulu, and then there are 3 now community entities that are established under the Aboriginal Land Rights Act as an entity, and they cover the townships of, as of the 1st of October, Groote Island Township, Gunyangara in Ski Beach, and Mira hold their lease in the township of Jabiru.
So that's
Senator Nampijinpa Price, I do also need to flag that I understand Senator Stewart has questions in this outcome. So I need to ask you, I will go to her and then ask for a reflection from you and any other coalition senators or senators online, how many more questions you have for the Office of Township Leasing. Just noting that we are due to go to the next outcome, but I do note while we had half an hour planned for township leasing, at least 10 minutes of that was taken up with opening statements, etc. So I envisage it's okay to go a little bit over. So did you want to conclude your questions or do a rotation?
I've got more questions to ask.
Okay, if that's okay, I'll see. I'll see if Senator Stewart wants to take the call now. I know she's got a bub with her, so she may not be able to jump on straight away. But I will just wanted to flag what progress we're making, and then I'll let you continue now, and either myself or Senator Stewart will take the call. So please keep going, Senator Nampijinpa Price.
Okay, thank you. Can you please just outline what the difference is between the economic development function of the Office of Township Lease in comparison to the NIAA function, who also have economic development officers?
Thank you, Senator. I might answer my part and then Ms Bruin may interject here. So my role is primarily focused on enabling townships through the secure tradable tenure, to secure subleases and to apply sound administrative process to that secure tenure. The other part of my role is to facilitate economic opportunities for Aboriginal landowners and communities. So what the difference probably there fundamentally is that should traditional owners either see an opportunity or an area that they would like to develop, so that I might go out for an expression of interest to the market to say that there may be land available for development for this purpose, or whereby traditional owners may decide that they want to proceed or progress a specific economic activity, and how I can have touch points through my role where there may be funding available or opportunities through a joint venture with an alternate developer. In saying that, where there has been commercial or economic enterprises development opportunities available, we will support traditional owners if they want to go into that business themselves with some advice to ensure that they are fully informed of the decision. So what I can recently probably provide an example of is the Milakarpiti Fishing Lodge recently was placed under administration for sale. Traditional owners, we saw an opportunity for the Woolly Ranku traditional owners to actually have first right of purchase of that facility, because there was also some stimulus funding that was received by the land councils. So what we did provide for the traditional owners of Milakarpiti, so the Woolly Ranku traditional owners, was to buy in independent expertise to allow them to do the financial analysis to establish if it was a financially viable project for themselves. And then they made a determination on that. They were able to purchase the facility, and I facilitated the land tenure arrangements for them to ensure that they had secure tenure. So that's my primary role. Senator, does that answer your...
Thank you. Yeah. And I guess the difference with... I can come back to NIAA with regard to that afterwards. So in the State of Service report delivered by the Australian Public Service Commission, can you tell me, hang on, that might be, The OTL has the second highest rate of unscheduled absence rate from 2021 to 2022. Sorry, that's an NIAA.
I was going to say, sorry, Senator, I was going to say that's news to me.
NIAA has the second highest unscheduled absence rate at 15.2% from 2021 to 2022. Are you able to, and this might have to be taken on notice, but if you could provide a breakdown of the rates for the Office of Township Leasing in terms of retention rate for staff, how many absent days with no notice, sick days with notice, sick days without notice, contract staff in terms of contract, and how many staff have commenced and how many have left in the last 12 months. And if there are any cases of bullying that might have been lodged. If that can be taken on notice.
Yeah, Senator, thank you. I'll take that on notice. What I can advise the committee straight up is there's been no formal bullying cases received by my office, but I will take the other matters under notice. Thank you.
Thank you. Now, in the case, there's two safe houses, one in Hermannsburg and one in Ludgermanu. How many other government departments have leases with the Office of Township Leasing that occupy either of those centres?
Senator Price, I'll jump in once you've asked these questions, because I had some questions on behalf of Labor senators as well. But please conclude this one and then I'll jump in after that.
Sorry, Senator, can I just ask the locations again? I just missed that.
Hermannsburg and Ludgermanu.
So just for the committee's information, I also hold under my statutory functions Section 19 leases over government assets and also housing precinct leases across the territory on behalf of the Commonwealth. I can advise you that I do hold a lease over Hermannsburg and Ludgermanu for the purposes of a GC, and I also hold the safe houses in both Hermannsburg and Ludgermanu. That is through an MOU arrangement. So the safe house arrangement is through an MOU arrangement with the NIAA, and they have my primary function is to work with the land councils to ensure that the lease conditions, terms and conditions are met, and for any tenancy purposes, that the NIA engage directly with the sublease holder, the tenant that may be residing in that for the purposes of providing safe house services. I'd also it's just important to note, Senator, that my funding directly received out of the Aboriginal benefits accounts does not cover any of the in Commonwealth assets. That is on a cost-neutral process whereby I invoice the agencies that I hold those leases for to cover those costs.
Thank you. Look, I guess what I'm trying to understand is I've personally visited some of the safe houses. I know that in Hermannsburg, the safe house is quite a small facility, and there are other government departments leasing the same asset, and that just my concern around it being a safe house and meetings being held in that safe house through other members of the community, given that it's a safe house, that there's that co-occupation taking place, I find it concerning.
So, Senator, I actually, like I said, we don't run the program. As long as the lease is being used within the permitted use of the Section 19, I would probably have to defer that question to NIAA, Ms. Bruin, because, like I said, we don't have primary responsibility for the Safe House program, or the delivery of Safe House services.
Yeah, thank you. We might come back to that as well, I think, in our session, if that's okay.
Thank you.
Senator
Yeah, just like to
Nambajimpa
get to
Price,
know
I need to.
who has those subleases, that's all. Given it's a safe house, I think its primary purpose is taking care of the safety of vulnerable women and children in the community. So, yeah, I'd definitely like to get to the bottom of that one when we can.
Senator Nambajimpa Price, I'm now going to give the call to Senator Stewart. And can I ask how many more questions you have? I guess I just remind you that Labor senators have a bracket of questions, and that the longer we go now in township leasing, will come off the time that we have for the next outcomes, noting that we will need to finish at 11:30 Eastern Time sharp, which I think is around 10:30 your Northern Territory time. I'm not quite sure. Senator Stewart.
Thank you, and apologies for needing to step away. Ari was telling me that he wanted to take a nap, I'm sure some of our Western colleagues probably want to do, given the time that we started this morning. I've got some questions about the Office of Township, for the Office of Township Leasing and some of the models, as like for my curiosity more than anything else. And I saw that the Groote Eylandt community had a ceremony to mark the transfer of one of your leases to their community in mid-November. Are you able to just tell me what that means? I've heard Senator Nambajimpa Price talk about economic development. And had questions. I'm keen to understand what does that look like? If you've got some examples, that'd be really great.
Thank you, Senator. And I'm a bit tired, like Ari as well. I'm still on Darwin time. Under the Aboriginal Land Rights Act, the amendment has allowed for. The legislative instrument establishes the Executive Director of Township Leasing as an entity under the Aboriginal Land Rights Act. In more recent times, there has been an amendment to enable traditional owners to establish a community entity function to manage and govern in their own right a township lease. Each of the township leases, bar one at this stage, even though we're in a process with the Mantiupui family to ensure that that's inserted into their township lease. All township leases that are in partnership with the Executive Director has a mechanism contained within the legal provisions to enable a transfer to a community entity when and if they desire that to occur. So in the Groote Eylandt township lease, like I said, that covers the three communities of Umbakamba, Miliakbar and Anuragu. They requested that transfer to occur a couple of years ago, and myself and Chairman Warramaba addressed a whole of island consultative forum of that representative of the traditional owners of Groote, whereby they expressed their support to transition that township lease from myself to the Andiliaqua Royalties Aboriginal Corporation as the identified entity under the Aboriginal Land Rights Act. We successfully transferred that as of the 1st of October this year, and recently had an event out there. We remain in partnership with the Andiliaqua traditional owners. What I've also got to say is the entity then also brought in 4 of their homeland, also they call them satellite communities in Groote Eylandt, into the township lease that they now administer. So there's tenure, the same tenure principles for all areas where the Andiliaqua residents reside. So that's a real benefit of that transfer as well. Also, the partnership continues with the Andiliaqua families to ensure that we transfer knowledge and experience to continue to build on their capacity so that they ensure sound administration continues to occur for existing sublease holders.
So what are some of the things that you look for to be able to transfer a lease over? What are some of the things that the strengths, I suppose, of traditional owner communities that you're looking for to be able to do that? I really love it when we can celebrate our mob and the things that they are able to achieve. So I'm keen to kind of understand what are those things, what are the real strengths that the community showed for that to happen.
Yeah, so thanks, Senator. The area is quite a niche sort of area of operation, and there's a lot of knowledge between myself and probably the land councils, because they also administer tenure as well, that exist. And it's something that some time ago we recognised that how do we transfer that knowledge and experience into and I suppose safeguard that information and knowledge that survives, the people who operate in this space. And we have developed a draft township leasing framework that identifies key principles of the township lease model, from the agreement making process to if and when a transfer may need to occur. So there's been some lessons learned, because this is the first transfer, and it was through a strong partnered approach in it, where we identified some benchmark capabilities for the entity to establish to ensure the smooth transition, because we need to obviously maintain the integrity of the secure tenure with third-party providers, but we need to ensure that this is a traditional owner-led process. There's already good governing principles, particularly with the transfer, because they've been at the table for a long period of time. So they know what they're talking about in the business of, land tenure arrangements, which is fantastic to, be a part of and watch and observe. It's the administration where we have ensured that we provide that knowledge to enable that transfer to occur. So we create sustainable community entities now and into the future, because these leases are intergenerational. Some of these, they range between 80 and 99 years township leases, and sublease holders normally have anywhere between 5 and 40 year sublease, and have mortgages over that. So it's the secure tenure principles that we transfer that knowledge and experience through. And like you, it's something that myself and the office want to see continue to occur, that we support community entities establishment, but again, with ensuring that there's sound, sustainable, secure tenure principles that allow them to lead their governing and administrative environment. So we certainly see that there's, a lot of work to be done in that space and transferring that knowledge and experience.
Thank you. Can you, I'm keenly interested in self-determination and, of communities. Can you talk specifically to the that transfer and how those principles were enacted for that community, for the Islet community and the Groote Eylet community, and how did you ensure that you didn't have any kind of external interference in the process of people who didn't have the best interests of the community at its heart?
So thanks, Senator. It's a very partnered process that was undertaken with the Groote Eylandt Township lease transfer. Groote Eylandt, the Warrnambool families are probably in a very unique position, because they are establishing a very traditional owner-led process to bring back some primary services, functions of service delivery like health, education, justice, housing. So they've done a lot of work over 10 years to develop their local decision-making framework with the Northern Territory Government and agreement-making process there. They saw an opportunity to also establish as part of their vision, the transfer of the township lease also was a part of that process, even though it wasn't embedded into the local decision-making agreement process. We then worked very closely we are guided by the Consultative Forum Group. They are central to the decision-making environment. So there's an established trust through those environments. And like I said, there was decisions made and at those forums. And then we then took those decisions and worked with the Andiliaqua Land Council and went into a heads of agreement with them to set out the principles to progress this body of work. They did also buy in a level of expertise on their side as well to engage and, set the principles so they had, proper legal advice as part of their statutory functions to represent traditional owners of that area. So I think what was the success of this, again, was the partnering of enabling and bringing into, the vision of the Yandili people. So again, building that foundation of trust and, open and transparent processes. So uplifting our information into, a new entity requires, from our office, a lot of work, I'd have to say. But, we wanted to ensure that they had the information on hand so it allows them to seamlessly transition to this environment and continue to manage those arrangements without interruption. Sorry, does that answer your question?
Before you continue, Senator Stewart, I believe we have Senator Thorpe online as well now. Is that correct?
That's correct, Chair.
She may be mute. Thank you. I just wanted to make sure because I hadn't drawn the hearing's attention to that fact. Do you have questions for the Office of Township Leasing?
No, I don't. I'm in the next section.
That's fine. I'll allow Senator Stewart to keep going, and then we'll move on, conclude the Office of Township Leasing. Senator Nampijinpa Price has highlighted that she's able to put the rest of her questions on notice. So once Senator Stewart has concluded, we'll move on. Thank you.
Thank you. Just a couple more questions from me, if that's okay. What are some of the things that the community has told you have been the benefits of the transfer?
So there's, with all cases amongst, our people, there's varying different views. I think the main one to take away from this is that they are empowered through the decision-making environment, whether that's been through the consultative forum or now, the transfer to the community entity. And I think through the partnered approach and the open and transparent decision-making environment, this is a strength now that they'll take into the entity, which is a much more board-like structure. However, what they've done through that process is establish community committees, which is very similar to the consultative forum mechanism. So the strength of those decision-making environments have been reflected in the new arrangements. I think there's a celebration from the Yandili people that this is a vision of theirs that has been led by, their senior leadership, and it's the first to transfer through the agreement-making process. So the Commonwealth has obviously supported that, and the celebrations were, well received on community. Like with anything, Senator, I think, time will tell, and, there'll be different views that occur as they journey along their township leasing journey. And we've certainly, we've committed to, we don't just walk away from the process. So, that there's still a partnered approach informally with, actually there's still a heads of agreement in still place, but I think it's just a celebration and something that we should all celebrate alongside of them, and they certainly have the capability structures in place to enable that to happen. It's probably important to note it doesn't detract from, say, the Tiwi space, who platform most of their conversations through the township lease and are quite comfortable in their structures at the moment and still see that as a traditional owner-led process. So I think the ability to adapt and pivot to each area and traditional owner group is the strength in the model.
Thank you. Just one more question, Chair, if I can. I can see you're about to wrap me up. And you've just touched on that question that I wanted to go to briefly, but thank you for spending the time just to talk about what some of the strengths are of, our communities are in the Northern Territory in particular, because if you were to believe the headlines, you'd think that there weren't any. So I'm glad to have that on record about our mobs going from strength to strength and picking these responsibilities and leading their mobs. the last question I had was just about what your ongoing role is. You've mentioned it briefly, but I just wanted to understand what that looks like as well.
Yeah, thanks, Senator. Obviously,
Through the chair,
Oh,
sorry, can we stick to more specific questions, given we've had a briefing, or the briefing's been tabled with the role of Office of Township Leasing?
Sorry, was that Senator Nampijinpa Price speaking?
I think the
just missed.
question being asked is more specific to Penny's role, which she has explained in her opening statement and has tabled.
It's a legitimate question, and we will be moving on very shortly in any case, Senator
And I recognise
Nampijinpa Price.
that Senator Thorpe is also waiting for questions.
Okay, thank you, Senator Nampijinpa Price. It's a legitimate question for estimates, and it's not for me as chair or for other senators to determine what other senators would like to ask.
Sorry, through the chair, I just
So
noted that
I
it's already
will
been answered.
let
That's all.
Senator Stewart conclude her questions, and then you will have the call when we're able to move on to the next outcome. Thank you, Senator Stewart.
I've concluded my question. I just wanted to understand what the ongoing role of Office of Township Leasing is, and then I'm done.
Thank you, Senator. And I'll make it quick. So obviously my role is embedded in a legislative instrument, and it's to hold township leases as the Commonwealth entity. The role obviously described in what I've previously discussed and also within the opening statement is there. What I'd probably just add in response to your question, Senator, is the role of the Executive Director has evolved over 15 years, and I see the evolution of that continuing to happen alongside traditional owners. And the role will be very much guided by what the aspirations are of each traditional owner group. So whether they continue to see a partnered approach with the Executive Director of Township Leasing's position, or whether they see the supporting requirements through the community entity functionality. I think what is important, and I've described it in my opening statement, is there should be a positive role obligation on the Executive Director by leases held in partnership with traditional owner groups, that there is this continuous work that should take place to enable a transfer when and if traditional owners desire to transfer to a community entity. So that is a critical function, and it's really starting to embed itself in the office. So going from an administrative environment to facilitating economic development to probably having a strong focus on building and developing capability structures to allow our people to go in and govern their own environments.
Thank you, Chair.
Thank you. I now want to thank the Office of Township Leasing for their evidence today. I thank all the officers.
Thank you, Chair.
Well, I know you'll be moving it. I beg your pardon.
Thank you,
Sorry, was
Chair. Thank you, Chair.
No, thank you, Ms Talbot, and thank you to all of your officers. Now, while other officers are coming to the table, I will welcome them officially. I think we have Mr Blair Excel, the Deputy Secretary of Strategy, Evidence and Research Group of the Department of Health, Ms Jodie Bruin, the CEO of the National Indigenous Australians Agency, Ms Alison Frame, Deputy Secretary of the Social Policy Group of the Department of Prime Minister and Cabinet, Mr David Lewis, General Counsel, Office of Constitutional Law of the Attorney General's Department. And I'll just wait for a moment while I double check you're either at the table or online.
Good morning, Chair. Sorry, Blair Excel here, Deputy Secretary for...
No, that's fine. I did those preliminaries while you were all still coming to the table. I just, So because of that, I might just ask before you speak for the first time, if you're able to state your name for the Hansard.
Thank you, Chair. Letitia Hope, Deputy Chief Executive Officer, Policy and Programs. Just while others are coming to the
Great.
table.
Okay, and just let me know when you're ready for questions.
And you have Gavin Matthews, First Assistant Secretary of the First Nations Health Division, Department of Health.
Great, and I can see we've got Genevieve Quilty online.
Good morning, everyone. It's Genevieve Quilty, First Assistant Secretary, Social Policy Division, PM&C.
Great. Is there anyone else online? Great. Are we now in a position to go to questions, everyone? Okay.
Yes,
Do
thank
you,
you.
are
do
there
have
any
an
opening?
Yes, thank you.
You have an opening statement. Would you like to give it, or would you like to table it for brevity?
It's not very long, Chair, but I would like to actually make the statement.
Great. Okay. Over to you.
So, good morning, Chair and Senators. Jodie Broome, Chief Executive of the National Indigenous Australians Agency, Wandiwa. I'd like to start by acknowledging the Ngunnawal and Ngambri peoples on whose land we meet this morning, and pay my respects to elders past, present and emerging. And I also extend that respect to all Aboriginal and Torres Strait Islander senators and witnesses here today. I just have one question from our last appearance a few weeks ago that I wanted to follow up on, beyond those that we took on notice. Senator Namatjira Price, I was really reflecting on your question about the number of our senior executive service who speak their traditional language. And I indicated to you that we don't capture or hold that information, and also that it's not been something that has come up. We do, however, have some SES that speak their traditional language, albeit at varying levels of fluency, but it's not something we specifically ask for or aggregate in our workforce data. As you'd appreciate, this is a sensitive area, as it can be upsetting for people who have lost or had their language taken away in previous generations. So my own mother, and I'll use my own case as an example, my own mother is a member of the stolen generation, and so I will never be able to speak Inchibundi as much as I would like to. My mum was taken to an orphanage in Perth at age 6, and where she was punished if any of the children spoke their traditional language. So while she now lives back with family and community and has learnt some more of her language, my mum does not speak fluently, and as a result, my brother and sister do not either. So I just want to make that point, that having your language taken away or suppressed doesn't diminish our connection to country nor our identity as First Nations people. And this is why the revitalisation of Indigenous languages is a priority for government, and the Closing the Gap Target 16 goes towards a sustained increase in number and strength of Aboriginal and Torres Strait Islander languages being spoken by 2031. This includes continued investments through the Office of the Arts, Indigenous Languages and Arts program for First Nations people to express, preserve and maintain their cultures through languages and arts. This includes operational and project funding for the peak body First Languages Australia, the Australian Institute of Aboriginal and Torres Strait Islander Studies Indigenous Languages Dictionaries project, placing First Nations educators in 60 primary schools to teach First Nations languages, and a range of interpreting services so people have equal access to government and legal services, and to provide employment opportunities for Aboriginal and Torres Strait Islander people who speak an Indigenous language. The government is also proud to be supporting the United Nations International Decade of Indigenous Languages. I thank the committee and welcome your questions.
Thank you very much. I was happy to take that one on notice, and I think the point of my asking that question was my understanding that our most marginalised Indigenous Australians are first language speakers, and that it is helpful to know whether individuals like that are in positions, working in positions of higher management, because that I think is a really important target to be able to reach for that was the purpose for my line of questioning, because I'm fully aware that there are those first language speakers, our most marginalised Indigenous Australians, who don't have the opportunity to sit in such high leadership positions. Thank you, and I'm happy to take, like all other questions, to be tabled that were taken on notice.
Thank you, Senators and Chair. Happy to take questions.
Chair, we can't hear you.
You're on mute.
On
Chair.
mute.
Thank you. I'll take your previous remarks as a statement, Senator Nampijinpa Price, and I understand you're seeking the call to the coalition. Is Senator Little also seeking the call?
Yes, thank you.
Okay, we'll go Senator Nampijinpa Price, then we'll go to Senator Stewart, then we'll go to
Sorry,
Senator
that was
Little
Senator
and
Little
Senator
who
Thorpe
was seeking the call.
first. Okay, Senator Little, you have the call first.
Thank you. I just wanted to ask the question in relation as a follow-up to that question or that response that was given, and that is, and it requires just a simple yes or no, when you're meeting in communities where English is not the first language, is there a translator, and are the translated minutes of those meetings available to those who may have an interest in that meeting outcome?
Thank you, Senator. Look, I will pass to my deputy, but I think it would depend on the community and the wishes of the community as well.
Yeah. Senator Sam Jeffries, Acting Deputy CEO, NIAA. Could you just repeat that question again? Was it a question or was it a comment?
No.
Senator Little, you asked a clarifying question. Senator Little, you're muted. There was a question asking you to clarify your question.
Right, can you hear me now?
Yes.
Yes, thank you.
Right, thank you. Okay, thank you. My question is, as the lead agency responsible for Aboriginal affairs and therefore operating as you do in areas where English is not the first language, are meetings when your department or agency meets with those communities available, translated, and therefore after the meeting available to those who may wish to see the minutes of those meetings?
Mm-hmm.
Yeah. Thanks, Senator. Yes, we are often aware of the requirements that we need in community meetings, particularly if we need interpreters or translators. We also do have Indigenous engagement officers located throughout communities, particularly through the top end, who are first language speakers who assist greatly with the conduct and flow of meetings.
So my question is, are they translated and available to other members of the community, or only those that are attending that meeting?
I'd have to take that on notice, Senator, because, yep.
If you would, please.
Thank you.
I'd like to ask a question about Stronger Futures, given I've just sat through a harrowing few days in the Northern Territory looking at the impact of the cessation of the Stronger Futures legislation on alcohol consumption in Aboriginal communities in the Northern Territory. Can you tell me what impact advice have you been given as a consequence of increased alcohol consumption and the other social consequences as a result of that?
Senator, I might firstly refer to my colleague Tom Dyer, who's in Darwin at the moment online, but also I think there will be a collaborative response with also Mr Ben Burden of the Group Manager of Social Policy Group. So I'll firstly refer to Tom or to Ben. Tom, please.
Oh, thank you. Tom Dyer, Branch Manager, NIAA. Sorry, if it's okay, apologise. Can we just repeat the question one more time? I apologise with this IT issue.
Okay, can you hear me now?
Yes, thank you, Senator.
Right. The question relates to having spent a few days in the Northern Territory listening to the impact of alcohol accessibility as a result of the sunsetting of the Stronger Futures legislation. What advice has the Minister's office or the department got from key stakeholders about the impact of the cessation of that legislation in relation to alcohol accessibility?
Oh, thank you, Senator. With regard to advice, we've had a variety through various channels. So we're involved in a couple of groups that look at not only the impact of alcohol, but also the rollout of the changeover of the legislation. So we're currently engaged in a group called Alcohol Aspiration Committee, which the Northern Territory Government convenes. That group updates the NIAA, the Department of Health, and various stakeholders about not only the rollout of the changeover, but it gives updates as well as to the NT government's perspective of how that's going, which is a very broad-ranging sort of result. So with regards to it, we've been getting feedback that in the north, the impact, because of the changeover having very little impact, because alcohol prohibition was in place prior and is in place in many communities after, that the impact is low. We're also involved in a group that hopefully will be stood up soon, the Aboriginal Health Forum. We'll be looking to convene a group to look at the specific data on the changeover from Stronger Futures to the NT Liquor Act. We should be holding a meeting this week where we will look at the logistics of pulling that group together. That will include ourselves, the NT government, and the community control sector, mainly AMSAN, Aboriginal Medical Alliance, Northern Territory. So we are looking at such data and impact.
Can I ask, this may not be a question for you, but given that the Close the Gap targets, many of them have not even been reported in the Close the Gap report because they're waiting on data to assess the progress from the ABS. But the data, some of the data is available on the impact in the Northern Territory of the cessation of those alcohol restrictions without a proper transition plan. Can you tell me, there was some really clear messages of urgency, including from key organisations looking or advising that what's actually needed are special measures to reintroduce restrictions. Does the department have the same, and this might be a question for the CEO and the Minister, does the department have the same level of urgency that those organisations repeatedly told us there is in terms of the consequences of the cessation in the way it happened?
If it's okay, I might take some detail of that before the maybe handing over to my CEO. But with regards to the data for impact, the NT government have been publicly producing data that everybody can see on the data portal. It's fairly accessible on the internet. It shows police, hospitalisations, etc., across the Northern Territory with alcohol related. It's showing trends that are mixed. So, for example, Tennant Creek, the trend is falling. With regards to lifting trends of alcohol harm, under the Northern Territory Government's NT Liquor Act, the relevant Minister for Alcohol has the ability to prescribe alcohol prohibition on an area should harm be seen as an issue. Broadly speaking, I'm sure lawyers would have a more detailed version of that. And so that mechanism is currently in place, and we have spoken to the Northern Territory Government about the process to make sure the process of ensuring should harm lift, that the NT responsible minister is able to put that measure in place. And we've been assured that that process has been developed, should it be needed to be executed. So thought I'd provide that bit of detail, but hand over to my CEO.
Senator Sam Jeffries, I'll respond. As Mr Dyer had indicated, the Chief Minister holds that responsibility to act if it's required for appropriate alcohol policies and measures. But just wanted to point out, through the IAS, the NIAA invests approximately $13 million in funding in the 22-23 financial year to 12 organisations to deliver 15 alcohol and other drug support and residential rehabilitation activities in the Northern Territory. And through the 22-24 extension of the NT-RAE, the National Partnership on Northern Territory Remote Aboriginal Investment, the NIAA will provide an additional $11.072 million per year in funding for alcohol action officers and related harm minimisation programs. And the Australian Government recently announced a $3 million package to deliver more community safety patrols, youth services and family domestic violence support services in Alice Springs and its surrounding town camps.
Well, that's great to have the ambulance at the bottom of the cliff, but I just want to ask about, you mentioned that Northern Territory is the relevant jurisdiction, but we were given really clear indications that there is also federal jurisdiction that would have the same effect. So are you understanding the urgency that is coming from those communities, including from the key health organisation, the key Aboriginal community controlled health organisation, that said it's already put some of those Closing the Gaps target at risk? Have there been representations to the minister, any of the ministers, whether it's the Minister for Health or Minister for Aboriginal Affairs, or communications that have asked for special measures, intervention from the Australian Government or from the NIAA?
Senator Little, I just need to make this the last question before I rotate the call.
Thank you.
And then
Chair, you can't cut off this line of questioning at this point.
I'm not
That is seriously not fair.
cutting off the line of questioning. Appreciate it's important. That's why I've indicated it's the last set of.
Chair, it's not important. Every day that goes every day that goes by is causing an issue.
I'm giving you the call so you can respond.
Thank you. I'm looking for a wholesome response to the department. Yes.
Minister, you have the call.
Sorry, I'm not sure if you can hear me, but I wanted to be able to respond to Senator Little because I think her line of questioning is very important here.
Minister,
have I got the
you
call?
have the call?
Thank you. Thank you. Firstly, to answer your question, Senator Little, of course, we're very concerned around the alcohol situation across the Northern Territory, and it was certainly something that we looked into as soon as we got into government with the expiry of the Stronger Futures legislation, and myself and Linda Burney and Marion Swimder as the local member met with the Aboriginal community health sector to find out what was going on. So to answer your question around that sense of urgency, we're acutely aware of that. but we're also mindful that we have to go through the Senate processes of understanding what else in the Stronger Futures legislation also needs to be looked at. So whilst your inquiry is ongoing, and I know you're going to report in March, I guess to answer your question, yes, we are very concerned.
Are you able to provide any correspondence that's been received by NIAA or the Minister in relation to the reintroduction of restrictions or a greater response to that was predicted in the budget, given what people are actually feeling on and seeing on the ground every single day?
Look, I can certainly have a look, take your question on notice to have a look at any correspondence. I personally don't recall receiving any, but I will check in terms of Minister Burney and take that question on notice. I also think your question around whether any kind of correspondence focuses on the budget will be another element. So yes, I can certainly take those questions on notice for you.
Thank you. And has the Minister received any advice about using those Commonwealth powers? And can you table that if you've received that advice, please?
I'll take those questions on notice.
Thank you. As well as the impact on and the data that's available that explains the impact is mixed, and we've obviously asked for an improvement on that. Is the department doing any work, or the Minister doing any additional work, not just on the impact of the increase in drinking, but the impact of the increase in trauma on women and children as a consequence, and men as a consequence of the lifting of those restrictions, or the cessation of those restrictions?
Yeah, look, we've certainly asked the Northern Territory Government to assist with data collation, immediate data collation in terms of not only the alcohol, but entry into hospital, all of those concerns around women and children in particular. And I will hand over to the department because I'm not sure where that has actually landed at the moment. So if Sam Jeffries, if you're able to finalise where that negotiation is at for Senator Little, that would be very helpful.
Yeah. Thanks, Senator. Minister, I might refer to Mr. Dyer to give us an update on that. Thanks, Tom.
Thank you. So with regards to data and pulling together a group, we've tried to keep the group structured as per our Closing the Gap governance structure, as we do have a variety of governance tables across the Northern Territory on Indigenous affairs. With regards to this, we see it in the health sort of sector. So we've proposed the Aboriginal Health Forum as the vehicle that this will move through. And then this week, there should be a meeting between the NT government, NIAA, and the community sector to put the detail around that group. The group will be looking at the movement in data as a result of Stronger Futures. Having said that, at the same time, the Northern Territory Government is making publicly available trend data on alcohol harm in the Northern Territory, showing right back several years so people can see where that is at.
Senator,
if I can add
Little, sorry, I'll let the officials finish, but Senator Little,
Sorry,
I will need to rotate the call. You're more than welcome to, the coalition is more than welcome to use its time and come back to its priority questions as it wishes. But I will need to move to Senator Thorpe after this line of questioning, and then we'll come to Senator Stewart and then back to the coalition. Thank you.
Chair, can Ms. Jackson complete that?
Yes, please go ahead, Ms. Jackson.
Thank you. Rachel Jackson, Acting Group Manager, Central Group. I just wanted to add that through the Indigenous Advancement Strategy, the NIAA invests around $13 million in funding for the 2022-23 financial year to 12 organisations to deliver 15 alcohol and other drug support and residential rehabilitation activities in the Northern Territory, and through the National Partnership on the Northern Territory Remote Aboriginal Investment, the NIAA provides $11 million per year for funding alcohol action officers and related harm minimisation programs. And recently in August, the government announced a $3 million package to deliver more community safety patrols, youth services and family and domestic violence support services in Alice Springs and in surrounding town camps. And we've progressed the negotiations for those contracts, and the funding is due to be provided to those providers this year. Just to answer your earlier question about the other activities underway.
Thank you. I'll now move the call to Senator Thorpe. Thank you.
Sorry, through the chair, may I ask just one supplementary question and then that's it?
Yeah, that's fine, Senator Price. I'll just noting, of course, I'll have to balance the time out later, but thank you.
This might be maybe for the Minister and or Mr. Dyer in terms of the response with regard to intervening. I'd like to understand what your conversations with the Territory Government, what the threshold is for a response to take place, given that we have had, due to alcohol-related harm in Alice Springs, our CBD has been closed down during the middle of the day on 3 separate occasions, that 40 police have been brought to Alice Springs. Given that I know personally, I receive phone calls from distraught individuals from communities where it is understood that adults buying alcohol, drinking alcohol, dragging their children 500 kilometres into Alice Springs from remote communities to do that, and then driving back out to a community either drunk or with alcohol, and their children are missing out on school. What is the threshold for either the federal government or the Territory Government to intervene to deal with this crisis?
I'll certainly take that question first off, Senator Nampijinpa Price, and then maybe the department might want to go into some of the details around the funding. On the face of it, obviously the arrival of extra Northern Territory Police into Alice Springs has been a critical point and an important one to at least try and bring about some calm. That is obviously under the jurisdiction of the Northern Territory Government, and we certainly welcome what the Northern Territory Government is doing in that space. On the federal level, we are pushing in terms of funding for the organisations around Central Australia, youth programs and other programs to assist at the other end of this, and that's with parents and families. Clearly, there is sensitivities around interventions of any kind. We only have to look at the concerns around the intervention over the last 15 years, which is perhaps another reason why the inquiry that's underway of the Senate to look into Stronger Futures is going to be an important report, I think, in terms of the advice that that committee gives to the Senate as to what the next steps should be. But at this point in time, we're obviously wanting the Northern Territory to keep doing what it should do, and that is to keep Territorians safe.
Sorry. Yeah. Thank you, Senator.
I would just suggest that the NIAA is a member of the Social Order Response Implementation Council that is convened in Alice Springs. We meet fortnightly, and we're definitely listening to the views of the members of that council, including traditional owners, and that implementation plan is being actively managed, which informs our approach.
I'll now give the call to Sorry for interrupting. I think it was the delay. I thought you'd finished.
Oh, sorry, Senator.
Please continue.
And just to add, the question was, what was the threshold for the Northern Territory? The threshold for the Northern Territory to implement prohibition through the Liquor Act is discretionary to the Minister. So the NT Minister for Alcohol can apply that measure as a discretionary measure, as we've been briefed on. With regards to Alice Springs, there is also bylaws in place that prohibit drinking in public places. And of course, there's laws under the NT Liquor Act, or application of the NT Liquor Act, that prohibits consumption of alcohol on premises, and also consumption of alcohol in the majority of remote communities around Alice Springs.
Isn't preventing alcohol from getting to places, because people now think that they can take alcohol out in those communities because of the end of the... Anyway, thank you very much.
I now give the call to Senator Thorpe.
Thank you.
I'll give you, please try and, we've got, I think, an hour and a half left. So I'll try and give you the call one more time, and you'll have about 10 to 15 minutes now, Senator Thorpe.
Thank you, Chair. My first question is, does the new Labor government have access to bureaucrats like yourselves to provide briefings and updates on request? Hello? Hello?
They did hear that question. Did you hear the question, officials?
Yes, thank you.
Senator Thorpe, you can't see the
Yes,
screen,
thanks,
but just-
Senator. Yeah, we did hear the question. But can you repeat it again? I'm just trying to get the context right.
Senator Thorpe.
You're quite
the bureaucrats
difficult to
at
hear.
the table,
Yeah.
do the bureaucrats at the table have access, or does the new Labor government that is in government right now, do they have access to the bureaucrats at the table upon request?
I'm not sure what you mean by access.
So if the government says to a government official like yourselves, we would like a briefing, or we have questions on a particular project or funding, is that, do you go and talk to the government upon request? If the government asks you to go and see them about something, do you go?
Yes, Senator.
Sorry,
Okay.
Chair, may I respond to Senator Thorpe?
Yes, Senator McCarthy, Minister.
Okay. Senator Thorpe, if there is a request from a Northern Territory Government Minister for a briefing from the Indigenous Affairs area federally, that is usually a formal request that comes through. I certainly have received requests through ministers seeking a briefing. Then there is also another level of briefings which could be at departmental to departmental briefings between the Commonwealth and the Northern Territory, or any jurisdiction for that matter. So it really is about which kind of briefing you're wanting to better understand.
I'm talking about the amount of time that Labor use in estimates, and how long it's taken to ask a question and how long the response is given. I think it's very, very good strategic time waster. And I've been waiting on the phone for an hour to be able to ask my question. So that is where it's coming from. And maybe the government needs to use their time wiser so that the opposition can ask questions for our community.
Senator Thorpe, Labor has taken just 10 minutes of the last 1.5 hours. And so
I've calculated
I will
more than
just
that, with all
remind
due
you-
respect, Chair.
I certainly, I have taken a record of all of that, and the
Okay,
Labor
well,
senators
I'll
have
get on
had
to my
about 12
questions so we
minutes.
don't waste any
Anyway,
more time, if that's
you make the
okay.
most of your time by asking some questions,
Okay,
and I'll
I
give
just
the
wanted to
call
get
back
that
to you.
clear.
Thank you.
Because I have a number of questions from community and I don't want to waste anyone's time. So my question is, it has come to my attention that the department will be conducting, this is NIAA, a review on Queensland South Native Title Services and other Native Title rep body in 2023. Is this correct?
Senator Letitia Hope, Deputy Chief Executive Officer Policy and Programs. We're just going to get the officer to come to the table.
Thank you.
John Litchfield, Acting Branch Manager, Land. Could you just repeat the question, Senator, please?
Are you undertaking a review of Queensland South Native Title Services and other Native Title rep bodies in 2023?
That's correct, Senator. It's a broader review of all the Native Title representative bodies and service providers that the agency funds. We fund 13 Native Title rep bodies and service providers, and there's a review commencing early in the new year.
Okay, have you got the terms of reference there?
I believe the terms of reference go to whether each organisation is performing its functions efficiently and effectively, has appropriate processes.
Could you provide that on notice?
Yes, certainly, Senator. We can provide that on notice.
Thank you. And how are you going to get traditional owners involved?
We haven't yet finalised the reviewer through the procurement process, Senator. However, a consultation plan for the review will be developed by the reviewer once engaged.
So it won't be just the corporations or the prescribed body corporates, it'll be the actual traditional owners who don't usually get a say or are at the table. So you'll be getting those people involved as well. Is that right?
Senator, ultimately this will be a matter for the reviewer, but our expectation would be most reviews of this kind would allow for the clients an opportunity to have their say in the review.
Is that in the terms of reference?
I believe that the consultation plan will be finalised by the reviewer. I can probably take further detail on notice, Senator.
That'd be great. Thank you. So it's also my understanding that there's some First Nations people that are being disadvantaged in native title proceedings, and there's complaints from First Nations people about unfairness, inequities, particularly funding research and legal assistance for native title proceedings. And some First Nations people are actually funding their own native title claims. So what are you doing, or what are you doing about that, or are you investigating this as well?
Thanks for the question, Senator. It's probably fair to say at this point of the native title process, after 30 years, the remaining claims are more contested, and certainly the agency is aware of dissatisfaction from clients of native title rep body services providers. So we have a very dedicated process to respond to that, and we take it very seriously. We work very closely with the Office of Register of Indigenous Corporations, where obviously the prescribed bodies corporate are regulated under, and also the National Native Title Tribunal in the Attorney General's portfolio on these matters. And ultimately, once these matters are brought to the attention of the relevant native title representative body or service provider, and they have finished their mandated internal review process, which is one of the things that we fund them for that they must have, ultimately there is provision for the agency under the Native Title Act. It's under Section 203 FB to ultimately appoint an independent reviewer where the facts at hand can be independently assessed and then a decision made. And we typically have perhaps 1 to 3 of those independent reviews every year, Senator.
Thank you. So are you aware that actions of some native title rep bodies and their service providers are using taxpayer money to take legal action against First Nations people in native title proceedings?
I'm not sure if I'd characterise it that way, Senator, but certainly there's the capacity for a native title rep body or service provider to brief out independent and separate representation for clients. So to give an example, a generic example, if there's a claim on foot and the native title representative body or service provider is representing that claimant group or groups, there may be a further claimant group that comes forward, and to ensure that that further claim groups gets the right representation before the courts, there's a practice called briefing out, Senator. So
I understand that. I've
if that's
also
the characterisation,
I understand that, with all due respect. I've also been part of native title for 30 years myself. But my question is, has taxpayer money been used by native title representative bodies against other First Nations in native title proceedings? Has taxpayer money been used against blackfellas in native title proceedings from the rep bodies that you fund?
So I'd probably have to take the actual detail on notice, Senator, but typically in a native title proceeding, you're correct, approximately $120 million a year is provided to our network of native title representative bodies and service providers to represent claimants in the courts.
Yes, I understand that.
So as I said, if there's a briefing out function to have legal representation to another claimant group, potentially that could be characterised, as you suggest, that there is IAS funding going to a native title representative body service provider who are engaging representation in court, and there's separate government funding through the funding that is provided to the native title rep body service provider to a independent law firm through a briefing out exercise, and those issues are raised in court so that all clients and all claimants have their day in court and have fair representation, Senator.
So I'm correct in saying that taxpayer money is used by native title rep bodies to take legal action against other First Nations native title proceedings. So is that a yes or a no?
I think it's important to note that each claimant group, once threshold levels are met, have their right to representation of their claims once they've met threshold tests before the courts, and that's to ensure that they can have their say before the courts.
I understand
Senator.
that. I think you're not answering the question, and the question is, again, are you aware of any taxpayers' money being used by native title rep bodies against other First Nations native title proceedings? Are you aware of any?
I'd prefer to take
Yes
that
or no?
on notice, Senator, and I gave the description earlier where that is part of the system before the courts, where you'll have Australian government funding to essentially all sides of a proceeding, and that could include various claimant groups, of which some claimant groups
I'll get you to take that on notice.
Thank you,
I
Senator.
get what you're saying. Thank you. So what are you doing, or will you investigate complaints of conflict of interest of native title rep bodies and service providers in native title proceedings?
I think you referred to the independent review that will be commencing early next year, but that followed from a review of the sector of the native title representative bodies service providers over the last 3 years, which has informed the decision making that the agency makes on their levels of funding. and the opportunity for the review that starts early next year is for all clients to be able to have their say. And I'd make the point that the agency does receive representations and complaints, if you like, and all those ones that the agency receives at this point in time will be referred to the reviewer once engaged.
Okay, could we see the terms of reference for the independent reviewer?
I think I earlier undertook to take as much information as possible on the review under notice, Senator.
Great, thank you. And that's my questions there. I'd like to ask some questions on health to the Department of Health, so thank you for answering.
I think you're on mute, Chair.
Thank you, Senator Thorpe. I'll now give the call to Senator Stewart, and then we'll come back to the coalition, and then back to Senator Thorpe.
Thank you, Chair. And I'm sure Senator Thorpe will be pleased to know my questions to health as well, so there hopefully won't be too much time in transition for moving chairs. Just a couple of weeks ago, we had the Closing the Gap statistics reported, and even though it pains me to talk about the gap and deficit that our mobs experience, it's important to spend some time focusing on it. One of the things that the opposition leader got up and said was that he's proud of their record while they were in government, of their contribution to closing the gap objective, which I find funny considering one of their first acts was to cut nearly $1 billion from First Nations programs when they came into power nearly a decade ago, and failed to deliver on a $40 million promise for cultural water and cut over $200 million from Aboriginal housing. So it's really kind of no wonder that only 3 of the 17 closing gap targets are on track. So I do want to just spend a bit of time unpacking what's in the budget and how they will go to achieving some of the outcomes that we hope to see our First Nations mob get to over the next little while. So the government has invested $314 million over the next 5 years. I've got some specific questions about some of the measures, some of the things in here, but are you able to kind of speak to broadly kind of what this budget does to address some of those measures, like life expectancy gap measures?
Yeah, thank you, Senator. So, Gavin Matthews, First Assistant Secretary of the First Nations Health Division, Department of Health. Look, thanks for the question. So, I think what you're referring to is that in the budget, there, in the October budget, there was $314.5 million committed over 5 years for First Nations health outcomes. So I think it would probably be safe to say that all of those would contribute strongly to particularly the health outcomes in the Closing the Gap agreement. But of course, health also, the targets are very interconnected across many of the fronts. So I can sort of go through them. The 314 probably breaks down into some reasonable things. So there's $45 million for 34-chair renal dialysis units. So of course, chronic kidney disease and dialysis is a major and significant issue for many Aboriginal and Torres Strait Islander people, unfortunately. So that will, increase the capacity for renal dialysis, and probably the intention there is to get renal dialysis connected closer to people, particularly in, in outer regional and remote locations where they often have to travel long distances to access dialysis, and quite often then don't, undertake the frequency of which they need to, which increases hospitalisations and those sorts of things. So, because it's a really good opportunity to have a look at how that model works and up the capacity, particularly in regional and remote, that we think will make a good difference there. So that's quite a strong commitment there. There's also, in that theme, there's $1.1 million for, some 2 dialysis treatment buses in far western New South Wales region as well, and the same thing. So it'll be mobile buses for similar reasons. There's a fairly significant commitment for infrastructure in the budget as well. So there's 164.3 million for new and enhanced infrastructure. That will support about 17 health facilities across the country, and they are both urban, regional and remote. And the intention there is to really, as we're, one of the commitments in Closing the Gap is to build and support the community-controlled organisations. And of course, the community-controlled health sector is one of the larger sectors that are there. So that will put in some very significantly upgraded, improved and new facilities in a range of, in 17 places that will definitely increase people's capacity to access quality healthcare for that, which sort of builds on a earlier infrastructure commitment as well, which gives us a very significant investment in the ARCHO sector, which is a great thing. So that's a fairly significant commitment. There's also 54.3 million over 5 years to provide up to 500 health worker traineeships in the Aboriginal community controlled health sector. Obviously a lot of narrative around workforce and pressures on workforce in the health sector generally. So this is a really significant outcome for the sector itself. The money will run through NACCHO, which is the National Aboriginal Community Controlled Health Organisation, which is the, as you probably know, the central peak organisation for the ARCHO sector. So that funding will go through them to, basically to provide Aboriginal health workers and practitioners over that, over that 5-year period. And that'll be a good thing about the sector growing and supporting its own workforce, and particularly a very strong Aboriginal Torres Strait Islander employment outcome out of that. There's also $22.5 million for a Birthing on Country Centre of Excellence for Waminda on the south coast of New South Wales, which will build pretty much a very significant birthing, First Nations midwifery-led birthing on country model for the south coast region of New South Wales, so sort of around now Shoalhaven region, which is part of an overall thing of slowly but surely building that practice of, culturally appropriate birthing for Aboriginal and Torres Strait Islander people. That obviously there's evidence is growing that the more we can do that, then the positive outcomes of a positive start to life around that. So that's a very significant contribution as well for that. There's 14.2 million to increase funding for rheumatic heart disease, for screening, prevention and treatment services, which will go on top of the existing investment for rheumatic heart disease and the rheumatic fever strategy. That will again run through the community, through a delivery mechanism we have through NACCHO, double the funding that goes in through that, and also has $1.5 million to basically provide some portable echocardio machines as well to increase detection, and also importantly to provide the training out for the sector to do that. There are a couple of other things as well in that package. So there's about 10.1 million for a second care flight helicopter for the top end of the NT, and about 2.2 million for AFL in the Northern Territory that will go into support Aboriginal people's participation in AFL and support in the Northern Territory. So those really, I think, there's probably also one other that's a relatively small one that's about 740 for renal and cardiac care services in 2 Aboriginal medical services in New South Wales, which will go to Tharawal and the Redfern Aboriginal Medical Service as well, to provide renal and cardiac facilities and training and machinery into those services, given that they're prime locations of where they are for high needs populations. And all of that will, I think, anything we get into in the health space that we can provide from that will put a genuine lift into the health outcomes for Aboriginal and Torres Strait Islander people.
Senator Letitia Hope here, if I can just add to complete that very comprehensive package. There are also 3 other additional measures, Senator. $2.72 million to improve the quality of healthcare and wellbeing outcomes for First Nations people by enhancing the community amenities at Marina Aboriginal Corporation Association, the Mingaletta Aboriginal and Torres Strait Islander Corporation, and the Glen for Women.
Probably the only other thing I would add is that all of these measures, also just important to probably note that they will all be delivered consistent with the principles of the Closing the Gap agreement. So they will be done in a genuine partnership with the sector and Aboriginal and Torres Strait Islander health leaders to design, basically to work out the arrangements of those and deliver them. So they won't be just a normal process. They will be done completely consistently with the principles of Closing the Gap.
Thank you, Senator Stewart. I'm going to rotate the call now. Who from the coalition is seeking the call, please? Otherwise, I'll go to Senator Thorpe and we'll come back to the coalition. Have you finished, Senator Stewart?
I did have a couple more questions, but I'm happy for it to.
Okay. Thank you. Senator Thorpe.
Thank you, Chair. I just have a couple more questions left on the NIAA. So the relationship, So just again, in terms of what your department's doing in relation, with regards to the relationship between funding for native title claim groups and the outcomes for these claim groups.
Thanks, Senator. The officer's just coming to the table.
Thank you.
John Litchfield, Acting Branch Manager, Land. Could you repeat your question, please, Senator?
I'm just inquiring about what you're doing or what you'll look into in terms of the relationship between funding for native title groups and the outcomes for these claim groups.
Probably if I, Senator, building on the answers to your previous questions, we do a continuous review mechanism of our native title service providers and representative bodies. One of their legislated functions under the Native Title Act is to proceed with those matters, and certainly the reviews we conducted between 2017 and 2019 and 2022, I should say, went to progress of native title claims. It's fair to say, though, that every jurisdiction in Australia is very unique in the way our claims are progressed, and it's difficult to make quantitative comparisons. So there's a lot of qualitative work done through that review to inform the decision-making around funding levels for the representative bodies and service providers. And as I referred to in my earlier answers, that previous review was a rolling review of representative bodies over 3 years. It's probably fair to say that makes it a little bit more difficult for officials to make judgments in our budget cycle. So what we've decided to do this time is to have the review of all our representative bodies and service providers next year in the one calendar year to inform future funding decisions on the outcomes that those representative bodies and service providers are doing. I should just make one clarification on that. We fund 14 native title rep bodies and service providers. One, GBK in Torres Strait, is new. It's only commenced on the 1st of July, so they won't be subject to the review next year. So it's a review of the 13 remaining bodies, Senator.
Thank you. So what pathways are available to traditional owners to pursue or dispute native title claims if they can't access representation or funding through native title rep bodies?
Thank you, Senator. So the first step is for the particular native title representative body or service provider to conduct an internal review exercise. If a prospective claimant has not been accepted in the first instance, and once that internal review mechanism has been completed at the representative body or service provider role, a prospective claimant or client can come to the agency and we have the ability under the Native Title Act to commission a independent review under Section 203 FB of the Act. And earlier I mentioned that's typically about 1 to 3 times a year that those independent reviews are done. And I add that's a decision of the CEO of the National Indigenous Australians Agency. It's something that the agency handles and not the Minister under the Native Title Act.
Okay, thank you. What avenues are available to traditional owners to appeal native title determinations?
That's a difficult question to answer, Senator, and there are provisions which are more in the Attorney General's Department around the revisiting of native title determinations, and it's a matter for the jurisdiction of the National Native Title Tribunal and the Federal Court, which are both bodies in the portfolio of Attorney Generals, and I probably am unable to comment further on your question.
So does your department provide any support or assistance to those traditional owners who would like to appeal the native title determination?
We are aware of at least one case along those lines that has emerged recently, and we're ensuring that those parties have appropriate lines of communication with the National Native Title Tribunal in the first instance, Senator.
Thank you. So the government has committed to abolish funding for the Native Title Respondent Funding Scheme and the Native Title Officer Scheme from 2022 to 23. What support, financially and legally, will be available for Native Title respondents instead?
The Native Title Respondents Scheme is in the portfolio responsibilities of the Attorney General's Department, and questions around the change, or as you say, the abolishment of that scheme should be directed to the Attorney General's Department, Senator.
But Senator McGrath here, isn't this cross-portfolio? Can't they answer Senator Thorpe's question?
Be great to get an answer if someone's got one.
Thank you.
There.
We've just got someone to the table.
The official has just come to the table, Senator Thorpe. I know you can't see. The official has just come to the table, but I just want to remind senators that we have half an hour left. We have a hard deadline because senators have other commitments. If people can text me who is seeking the call so I can divide up the remaining time. And that is back to the witness now to answer the question.
David Lewis, General Counsel, Office of Constitutional Law, Attorney General's Department. Thank you for your question, Senator. I'm afraid I'm unable to assist you. I'm from the Office of Constitutional Law, and it was only the Office of Constitutional Law that was called from the Attorney General's Department today, and native title is dealt with by a different branch in our department.
Could you take that on notice and give it to the relevant person in your department?
I'm happy to take it on notice, Senator, and I'll see what they can provide.
Thank you. And I
Can I just ask what department it is? What part of the department it is?
Senator, there's a native title branch.
Thank you.
I have a question for the Department of Health now.
The officials are at the table, Senator.
Thank you. Has the department done any work with states around what it would cost to fully fund ATCHO officers in all public correction centres, and any cost-benefit analysis to this measure? So this is regarding healthcare in prisons.
Senator, it's Gavin Matthews from the Health Department. Hi. Look, I think the short answer is that no, I don't believe we've done in the way that you've characterised it in that way. As you know, I think there's been a lot of discussion around healthcare in detention settings for many years. So, which of the general provision of healthcare in detention centres, which, as you know, has been broadly under the responsibility of states and territories who, through the distribution of, GST and other things are actually required to provide care in those settings. So that remains a reason why the Commonwealth, hasn't from that point of view. I mean, there is a few, as an emerging practice, ARCHOs providing services into prisons, which we're enormously supportive of as a direction particularly for the states and territories to pursue. So it's happening in Danila Dilber are quite involved in Ondale and the NT, the Congress, in the Alice Springs Youth Facility.
So is that funding?
No, they're funded from the Northern Territory government, Senator.
So the federal, there's no federal.
Yeah, so what we do from a federal point of view, we obviously fund the base, well, effectively the core funding for the ARCHO services across the country, and slowly but surely growing and lifting the funding into that sector to sort of grow it as a sector over time. And so that really provides a very strong base in our view for the states and territories to increase their capacity and their role in detention centres. But realistically, because the states are required to provide that care, they should provide the additional funding needed for that service. And so the NTG have funded Danila Dilber to provide that in the Dondale facility, and will provide some funding for Congress to do that in Alice Springs. The ACT government provides reasonably significant funding actually for Woononga to Aboriginal Health Service to provide services.
Would you mind putting that on notice? I'm just aware of time, and my time's probably running out, and I do have some
we're
other
happy
questions.
to do so. We have answered this on notice before, and happy to provide a little bit more detail of what we know about
Thank
that.
you.
There's a few smaller arrangements emerging in some other places as well.
Yes.
Likely to come up under the Justice Policy Partnership that's been set up under Closing the Gap as a piece of work across the Commonwealth and the state too, Senator.
Thank you.
It's a lot of interest
I have
in this.
another question.
Sure.
What funds are available to ACHOs to pay them for providing such care given the exclusion of inmates from Medicare levies?
Are you talking about in a justice setting, in a detention setting?
Yes. So what funds are provided to our Aboriginal Health Services to pay them for providing the services that they are providing to inmates who don't have Medicare, who can't access Medicare?
So we don't fund. So ARCHOs, as I said, we fund Aboriginal Community Controlled Health Services to provide. Effectively, they get funding in two ways. We block fund them, what's called block funding. So we provide core funding into the ARCHO sector, and then we allow the sector under what's called a 19.2 determination to bill Medicare on, in addition to the core funding, which is different to what happens in a normal mainstream GP context. So they're block funded and pick up MBS to provide comprehensive care. That we don't allow. So the ARCHOs do not have the capacity to bill if they provide services in detention settings. So that my earlier answer, that states are responsible for providing and funding healthcare in detention centres. So in that examples that I gave, they are examples of the state governments providing funding for the services to go in. So generally speaking, it is state funding that goes into those ARCHOs that are going in to do it in that way where they've reached arrangements. Because of course the ARCHO also has to make arrangements with, there needs to be pressure from the state, the state to effectively marshal its correction system to allow the ARCHO to provide care in that setting as well.
Yep. Okay. Has the department spoken to the state? So your department has your department spoken to the states about conducting a comparison between what this would cost versus the legal costs that the Commonwealth and states incur appearing at inquiries into deaths in custody and the coronial inquest costs?
So again, I wouldn't characterise as the discussions have been like that, Senator. So one of the things I would say is that there was around October, there was a 6-hour Aboriginal Torres Strait Islander Health roundtable of all of the state and territory health ministers and the Commonwealth Health Minister, and about 90-odd representatives from the Aboriginal health sector that had had absolute discussions about the issue of healthcare and detention settings. So that's been extensively discussed in that way. The cost comparison from those things, there isn't a specific piece of work on hand at the moment to look at it that way. I mean, there have been numerous studies over the years, as I'm sure you're aware, about looking at, I think it's arguing for prevention and early intervention as opposed to that. So, but not in the context of that. I mean, the issue, and probably the reason for it is that, we wouldn't necessarily look at it that way because it's not necessarily a cost of Medicare doing it. It is a cost of providing healthcare, of which the states and territories should be providing now because they are responsible for it.
Okay, thank you. So what steps have the department taken to address the well-known limitations through care? For example, prisoners leaving prison with inadequate medication and through care support, no referrals to community health services, and essentially a lack of treatment for that period of post-release. What's
Senator
going
Thorpe, I'll
on
need
there?
to rotate the call shortly, but I'll give you a couple more questions and then I need to go to Senator Little. Please continue, officers. Thank you.
So again, it's probably less of a directly specific, piece of work. There have been past efforts around what was called prison to work that put some effort into the process of leaving prison, largely probably more from a, prison to work point of view, but that did have some aspects into health and trying to coordinate a little bit more effectively. There are quite a few RCHOs that do, look to provide.
What's the department doing?
What we're doing, Senator,
I want
is...
that doing.
So,
I want to know what you're doing.
Yep, so what we're doing is our prime focus is really on building and supporting and growing the Aboriginal Community Controlled Health Service overall to increase its capacity to provide for all Aboriginal and Torres Strait Islander people is really the prime thing that that we have doing in that space. So, the capacity for the RCHO sector that if that is, that is our core piece of work that we're doing to contribute to that aspect. It is an emerging area where, as I said before, there was a significant discussion also with the states and territories to get it on the agenda to prioritise this as an issue for health ministers nationally to look at more actively, which is underway at the moment, and then that will link up with what's called the Justice Policy Partnership that's been established under the Closing the Gap framework, which will also have an aspect of increasing that asset. So there's probably three parts to that answer, Senator.
Thank you. I just want to respond. It's not an emergent issue. So we've got over 500 deaths in custody. This has been an issue for decades and decades. So we've heard from the community that people are leaving prisons or detention very, very unwell with no one looking after them. And if the department doesn't take responsibility for that through leadership or through funding these ACCHOs accordingly, then I'd like to know what else you're doing.
Yeah, so that's why I definitely wouldn't characterise my answer as saying it's an emerging issue that people have just, obviously it's been a long-standing issue of people have been aware. I mean, I guess what I'm trying to say is that they're really, to do that effectively, we need a bigger, to grow the Aboriginal Community Controlled Health Network, because it needs to grow and get large. It services about probably 40 to 50% of the Aboriginal population at the moment, so we need to increase that capacity, which we've been increasing the funding to the RCHO sector to grow it from that point of view, so its capacity grows overall. Then I'm talking about it more as an emerging issue on the health minister's landscape of something that they actively will look at and follow through, and that was through the roundtable that happened earlier a couple of months ago. It definitely lifts the profile and the focus on that for all health ministers, and that will, I think, literally will now focus through into subsequent health ministers' meetings. And then, of course, as I said, the Justice Policy Partnership, it was also been raised in that context as a place to pursue that issue and actively look what can be done from here.
And Senator Blair Exall here, just to add, I think Mr Matthews' previous examples of the work we're doing in the NT and the ACT go to very specific encouragement, support, practical examples to strengthen the care in correction centres, to strengthen the support for Indigenous Australians in those facilities. So I think there's kind of actually 4 or 5 different paths that are actively being pursued here.
And in most jurisdictions, we also have formal, partnership meetings between the RCHO sector, the state government, and the Commonwealth from a health point of view. That obviously this issue is also something that we'll pursue through that. So we have a range of mechanisms.
Excellent. Great that you have all the partnerships. Let's make it happen.
Excuse me, Senator Thorpe. I now need to rotate the call. I was seeking to do that before, but I forgot to unmute myself. Senator Thorpe, I'll just allow the officials to finish answering that last question.
We're finished, thanks, Chair.
Okay, Senator Little.
Thank you. My questions actually relate to the voiced and constitutional recognition, so if you can have the right officials at the table, please.
Thanks, Senator. They're just joining us at the table. We're ready, Senator.
Yeah, thank you. I just want to ask, what does a bipartisan position on the Indigenous voice look like, and will it include consultation with the Parliament?
Thank you, Senator, for the question. Julianne Guevara, Group Manager, Empowerment and Recognition Group. Senator, as we had indicated before, consultations with community have commenced on the voice through a range of different mechanisms. The primary focus obviously has been on First Nations engagement, and so the First Nations Working Group and Engagement Group, which I've spoken about previously, are principal means of communication and discussion and consultation. I did, I think, indicate at our previous hearing as well, of course, that the Minister, the Special Envoy and the Assistant Minister have all been involved in discussions across parties and across jurisdictions. In fact, you may be aware that the Minister had a meeting with her state and territory counterparts last week, where they once again sort of reiterated their support for the government's process towards a referendum on the voice. Of course, that consultation with other jurisdictions is in fact across different parties as well, in terms of lead ministers in different states and territories. So there are different mechanisms currently underway to have consultations to try and gain bipartisan support. And indeed, I think the Minister, in some of her recent interviews to the media, has indicated her desire to try and secure bipartisan support for the referendum process.
Thank you. Minister Burney has said it will not. The government will not fund a yes or no public campaign. What are the rules for NIAA employees and contractors who are on NIAA business in advocating a position?
So, Senator, NIAA's role in the process towards the referendum on the voice is indicated in our corporate plan. So NIAA's role obviously is to assist with consultations with First Nations organisations and groups across Australia to ensure that there is awareness and understanding of the process. We also have a role in coordination across the Australian Public Service and supporting the government in the processes. That's all indicated, as I've mentioned, in our corporate plan.
Thank you. I want to go to the question about the draft words for a question to be put to the Australian people in a referendum to Parliament. Did the Prime Minister or any of his ministers conduct any public consultation to develop that word?
Senator David Lewis here, General Counsel Constitutional from the Office of Constitutional Law in the Attorney General's Department. I think officials here are unable to comment on exactly what the Prime Minister or ministers have done, but it is certainly true that the words that the Prime Minister announced at Garma were the process of a long period of public discussion about constitutional recognition of First Nations people, including a voice to Parliament and to the government. And in fact, those words that the Prime Minister announced were quite similar to different formulations that have been proposed by a range of people in public in the past, including in submissions to the 2018 Joint Parliamentary Inquiry.
Are any officials of the department aware who actually wrote those words? I know there's been a lot of discussion, but are you aware of who wrote those words?
Senator, I think as my colleague from the Attorney General's Department has indicated, there have been formulations very similar to that wording in the public domain for quite a few years post the Uluru Statement in 2017. If you look at institutions like the University of New South Wales, I know various constitutional academics, including Anne Toomey, they've all written on suggested wording for what the alteration would look like, the alteration bill would look like. I think as the Prime Minister indicated when he presented those words at GAMA, it was intended to be a starting point for consultation with the broader community. There are, of course, there is a specific process underway at the moment with a constitutional experts group which has been formed under the work of the referendum working group. That group of constitutional experts, there are 8 of them, are specifically tasked with providing advice to government and, of course, to the working group on the constitutional amendment.
So this is of a more general nature in relation to that work. It relates to the Broome Office of the Special Envoy for Reconciliation and Implementation of the Uluru Statement from the Heart. Have there been any changes to that office to accommodate that work?
Thank you, Senator. We're just getting the right officer at the table for that particular question.
Thank you.
Hi, Senator. Amit Jambal, Branch Manager, NIA. There have been some work undertaken at that office to be able to support engagement with cabinet engagements.
And what's the nature of that change?
There's been some IT changes that have been supported by the NIA and also the Department of Finance.
No resourcing changes?
No resourcing changes.
Right, thank you.
Oh, sorry, can I just correct that? There have been 2 advisors that have been afforded to Senator Dodson, one at the advisor level and one at the assistant advisor level.
Do that particular work. And their role is just to do that work?
Correct.
Thank you. I've just got a question in relation to closing the gap in the data. Is there another, would you like to add to that answer?
Thanks, Senator. We're just getting the right officers at the table. Senator, we have people at the table to answer your questions now.
Thank you. Motion that I heard last week in relation to the impact of the lifting the alcohol restrictions in the Northern Territory on the health and wellbeing of Aboriginal people in the Northern Territory. Can I ask, there are 7 targets in the Close the Gap report that have no new data to assess progress. Given the prediction that that data is going to be impacted by decisions, when are you expecting to have the data, the new data available?
Thank you, Senator. If I heard your Ian Bartholomew, Closing the Gap Branch Manager. If I heard your question correctly, were you asking about when data would be available next for particular targets? Is that right?
That's right. There's a Close the Gap report, and there's a lot of there are outcomes in there that have no update of data because there's no new data to update the progress.
Yes, Senator. So we can take you through those target by target, if that's most constructive.
Are you suggesting that there is actually data to update those outcomes? Because that report says no new data.
No, Senator. So the manner in which the Closing the Gap socioeconomic outcomes are measured are primarily through the Productivity Commission dashboard, and the requirements of the national agreement are that dashboard are updated at least annually. So the last update was provided in July this year, and so we'd envisage a similar update no later than the middle of next year. It is possible that there could be interim updates provided in the meantime. I'm aware that the Australian Bureau of Statistics, including through census data, has published some information. So subject to the validation processes of the Productivity Commission, that data could be updated, in the coming months.
Given one of the data outcomes that is on track, which is the enrolment of children in schools, but I've always argued the more important indicator is actually participation, and the low level of participation in many schools in remote and regional areas. Is there any consideration being given to by the group that identifies those targets to including data that actually tells you that kids are actually at school and not just enrolled?
So one aspect that could be considered, Senator, would be to explore additional targets. There are certainly the ability for all parties to the national agreement, given the partnership context, to explore additional targets, and so that would be a matter for the parties to consider more broadly. The other aspect which I would add is that under the existing targets, that there is a data development plan which was endorsed by Joint Council in August this year. And so where there are aspects of data across the country that require further refinement, whereas that there might be a need for additional data development or potentially the way that data is shared between the parties, there is actually a plan in place to prioritise those actions as well.
Senator Julianne Guevara, I just would add, I mean, there are obviously all of the targets for the 17 socioeconomic outcomes need to be looked at for their kind of intersectionality, because they are actually all related. So yes, while there is the target on early childhood education enrolments, and in the latest results, of course, that looks like it's on track. If you look at, of course, early childhood development, the attainment of Year 12 and higher education, certainly on the early childhood development, it's currently not on track, and we are still to have additional information on the Year 12 attainment and higher education completion. So there are sort of information points to look at in terms of not only, as you say, just getting children enrolled, but actually looking at whether that leads to better longer-term outcomes in the educational area as well.
Senator Pratt, this is my last question, and I'm not sure if you can answer this, so NIAA can elect who's appropriate. But we've heard that you're giving $2 million to AFL, and there's a whole lot of money that gets given for sport participation. Is there a criteria in that funding that those sports organisations do not visit those communities during the school term to avoid disruption to the school curriculum for those children that only attend a very small amount of time anyway? Because we also hear that the thing that is really a gap in those communities are school holidays programs. So I'm asking, is there a criteria when you give money that those organisations that are involved in sport do not deliver their programs during the school year term?
Senator, it's Gavin Matthews from Department of Health. So I think you might be referring to the initiative I talked a little bit earlier, which was the $2 million to the AFL NT.
It could be anything. It could be anything.
Yeah, so I think you're referring to the one that's been, there was $2 million provided to the AFL Northern Territory as part of the budget for participation in the Northern Territory. Look, it's probably not a program I run directly, so I'll need to kind of take some of the data to go and find that. I mean, generally speaking, from the Commonwealth, when we've funded sports programs of these things, they're generally done in a way to try and increase participation of youth or whatever, whether it's Aboriginal and Torres Strait Islander kids or others, generally, rather than being structured in a way that reduces the likelihood of that happening. I would imagine that's the case in this one, but we'll probably need to check, which we're very happy to get that on notice for you and find out whether there's anything specifically built into it. But generally, the aim is to try and do them to increase engagement and participation.
It's a more specific question across NIAA programs that fund activities in sport, and please don't give me an answer that says sport's important to education, because I get that. What I'm asking for is, are they discouraged from delivering sports programs?
This is your last question, Senator Little, and I'll go to Senator Stewart after that.
Are they discouraged from doing that to avoid disruption to the normal school curriculum, given the low attendance of kids in regional and remote areas?
Thank you, Senator. Ben Burden, Group Manager, Social Policy and Programs. I'm not sure that there's, again, similar to Mr Matthews, I'll go and check the details, but I'm not sure that there's a specific instruction to providers not to disrupt schooling. I think it would be that our work with providers of our programs would be to make sure that programs that we're offering in communities are done and that they're mutually supporting and reinforcing each other across their objectives, be it sporting or education or community safety or general youth engagement activities. We would be trying and working with communities to make sure that the programs that we're offering to deliver what the community wants are actually reinforcing each other and working together.
Senator,
Doesn't answer my
thank
question,
you.
but I'll keep pursuing those in other areas. Thank you.
Thank you, Senator Little. Thank you for those questions. I'll now give the call to Senator Stewart.
Thank you. Ari's decided to join us for the last couple of minutes. My question, I've got a couple of questions about the voice, and I feel like I'm going to run out of time probably with our 11:30 finish. But I'm wondering if someone would be able to just talk me through what the consultation process has been for the voice. We've heard people who are involved in the dialogues talk about a 5-year process. So can someone just explain to me what that looked like, please?
Thank you, Senator. So as I had indicated, since the government came to power, it's put in place a number of different processes towards the referendum on the voice. As I said, the primary process for First Nations engagement has been through the Referendum Working Group and Referendum Engagement Group. The Referendum Working Group has met now 3 times and in fact will meet again today. And the Referendum Engagement Group, which is a larger group designed to do a sort of outreach to...
Sorry, can I just...
Yes.
Like my question just related to the work that's happened before...
oh, sorry, Senator, yes.
The government.
So there's been there's obviously been extensive work undertaken on looking at the voice since the Uluru Statement of the Heart back in 2017. You may be aware, of course, there was a joint select committee back in 2018 which made a number of recommendations, including to undertake work on the voice design. That led, of course, to the co-design process, which was undertaken between 2019 and 2021. Consultations on that were quite extensive. There were over 9,400 organisations and individuals who were consulted as part of that process. And it is interesting to note that even despite the fact that it was not in the terms of reference to consider constitutional recognition of voice, I think it was in the order of about 88% of those who engaged in those consultations indicated their support for a referendum.
Chair, can I just...
Thank you. I can see the time's up.
Chair, can I just beg your indulgence? It's Letitia Hope here, Deputy Chief Executive Officer Policy Programs. I just need to make a correction to a question that Senator Stewart asked earlier. I believe I said 2.72 million when what I meant was 0.272 million. So 272,000 is the correct number for those health measures that I outlined.
Thank you.
Chair, just one final
we
thing.
have available.
Chair,
Senator Colbeck, yes.
Look, I just want to go back to a question Senator Little asked about the Prime Minister's consultation. Well, one of the officials said that the officials at the table couldn't answer it.
Are you raising a point of order, Senator?
Well, I will raise it in the context of a point of order then. I don't concede that the officials from the question was about consultation of the Prime Minister or any of his ministers in relation to draft wording. We were told that none of the officials could answer that question. I don't accept that response, and I'd like the question taken on notice.
Thank you, Senator Colbeck. You've put that question now on notice. I want to thank everyone for their participation today. if I could just ask officials at the table to stop shuffling their papers so that we can conclude our proceedings. I'm very sorry, it just knocks the mics out, and when they all get shuffled at once, I can't hear anybody. I want to conclude today's hearing with thanks from all senators and members. Thank you to Hansard and Broadcasting for your assistance. I thank the Minister at the table, and I now declare this meeting of the Senate Finance and Public Administration Committee adjourned. Thank you so much.
Thank you, Chair. Thank you.